board issued a number of significant decisions this year, particularly in the summer before member Kent Hirazawa's term expired in August. One significant decision was in the Trustees of Columbia University case, where the board found that graduate student teaching assistants were employees under the Act and could exercise their rights to elect a union and bargain collectively. These were individuals who were providing research assistance and instruction as part of their postgraduate education. And the board found that they did have an employment relationship with the university, and the fact that they also had an educational relationship with the university wouldn't preclude them from bargaining collectively and electing a union. This decision was part of the board's overall trend this year of attempting to expand unionization into areas that haven't previously seen union activity, and to just generally expand individuals' rights to bargain and to organize. The board continued to take an expansive approach towards joint employment this year. Last year, in the Browning-Ferris case, the board expanded the definition of when two entities could be considered joint employers. And this year, in their decision in Miller and Anderson, they took it another step further. In the Miller and Anderson case, the board found that temporary employees, so for example, staffing agency employees, could organize into a single unit with an employer's direct hires, even if the employer did not consent to that arrangement. And so this whole issue of joint employment really impacts all different types of employers. Companies that provide personnel services like temporary staffing agencies, or even services that provide janitorial work or custodial work, cafeteria work. And it also impacts those employers that use those services. So employers need to remain mindful not only of how their supervisors interact with temporary employees on a day-to-day basis, but also what their contracts say with, for example, temporary staffing agencies, how much authority they potentially could exert over those temporary employees. This year, the board's general counsel, Richard Griffin, took significant activity to aid union organizing when he issued a memo, a general counsel's memo in May of this year. General counsel's memos are sometimes directed to the regents and guide their litigation decisions, and are seen as a way for him to push forward his agendas and priorities. So in this memo issued in May, the general counsel directed the regions to really advocate for a change in law at the board. He directed them to argue that the standard for when an employer can unilaterally withdraw recognition of a union should be changed. So under the current law, an employer can unilaterally withdraw recognition when there's objective evidence that a majority of union members no longer support the union. Now, what he would like to see is that employers can only unilaterally withdraw recognition when there's been a decertification election actually held and a majority of members vote to decertify. So this standard would make it harder for employers to withdraw recognition from incumbent unions. The board has taken an aggressive approach in reviewing employers' handbooks and policies, and has actually issued several decisions this year invalidating policies that employers once thought were pretty standard to issue. So the board has taken aim at class action waivers, certain provisions in separation agreements, email use policies, and social media policies as well.